righty. Peace, love, and law, everybody. Welcome to In God We Trust Academy, the Lawman podcast. And today we are on episode 19. And as always, we appreciate each and every last one of you. We got a few more minutes before we be getting started. So make sure you guys are locked in with us. Appreciate it. A few more minutes, guys. We got about 5 more minutes before we get started. Minutes.
Yeah. So tell me why we arguing, and why you in my dreams again, and why you always wanna fuck with me. After all, we just friends. So tell me why it's love and pain, why your tears in my window pane, and why you let her scream my name. After all, we just friends. So tell me why we arguing, and why you in my dreams again, and why you always wanna fuck with me. After all, we just friends. Now tell me why it's love and pain, why your tears in my window pane, and why you let her scream my name. After all, we just
Yo,
friends.
the Stay Shop, what's happening?
I remember when
Appreciate
we
the
first
heart.
met, we made it official that we would only be friends. Seemed like the conversation
Got
we
about
had, yeah,
4 more
to an
minutes,
end.
guys.
You let me in your mind.
4 more minutes before we get
Just
started.
for me to see your concept.
You felt like it was nothing left. I opened my closet just to give you a second breath. Run, expecting me to chase, but I just get high, expecting to see your face. Now we touching and feeling the feelings, evolving into our hearts, and we about to evolve. You know what I mean, baby, some kind of way. But I just see that in the future. But tell me one thing without this thing mixed in. How can we friends? So tell
That's
me
what's
why
up.
we
That's what's
arguing.
up. All is well, man. All is well. Continuing to keep it moving. Ain't no stopping.
After all, we just friends. So tell me why it's love.
No stopping, baby. Hey, y'all, check this out. We got something to tell y'all, man. So, y'all do know we had the car giveaway Saturday. Somebody won, but they gave the car back and said that somebody else should win it because they can't come get it. So here we are. The car is going to be given away at the conference. All right. So Saturday, there will be another drawing for the car. If you've already placed yourself in, then you're good. If you want to get more to put more in, then you can do that as well. Just do the same thing you did the last time, right? But still plenty of time, still plenty of opportunity. We're gonna do it at 7 p.m. Central Time, which would be 8 Eastern Time. Even though we're going to be in Atlanta, that's when we are going to be doing the drawing, right? At the conference. So you still got plenty of time. This card is definitely meant for somebody because ain't no way he just gave it back. But we still gonna make sure somebody still had the opportunity to win that though, right? God's Law, My Salvation, the conference, the big conference, right? You truly want to understand majority status, take control of minor accounts, rights, due process, jurisdiction, legal remedies, and you want to do it all according to the law. You don't even want to have to guess. Not even, I got to put one and one together and all of that to get two. And we're going to show you directly. Because the law is made public and it has to truly define itself at all times. So just make sure that you are ready for this conference, man. And if this is what you're looking for, then hey, we'll see you there. For sure. How y'all doing up in here?
Blessed, man. Blessed to be with you, man. It's crazy how all that went down. I ain't gonna lie. That's funny.
That's crazy, ain't it, bro?
Yeah, man. I was looking at the live, like, oh my God. When y'all seen the video afterwards, and you said, oh, like, oh wow, that's crazy. That's meant to be for somebody, though. That's gonna be meant to be for that specific person, bro.
It's meant to be.
That's gonna be God given. Yeah, bro.
That's what you call God given there for sure. Cause like I wasn't expecting it. I wasn't expecting to hear that. And when he said it, he was like, yeah, I'm not gonna be able to come pick it up. And I was like, I would have found a way, bro.
Never believe that, right? I'd have found something to do, man. Somebody send it to me. Hey, I'll pay extra. You know what I mean?
I'll pay extra, whatever it takes.
Yeah.
We're gonna get that car. You know? Yeah. I was wondering everybody's reaction, especially those who are already into the drawing. Like, how did you feel when y'all heard that and you know your name was in there? You know that your name didn't get picked. How did that make you feel?
Man, my eyes brightened up so fast. I was like, what? Oh, man, there's still a chance in there. Take that chance.
I still get a chance. What? You know what I mean? Like, I know y'all was like, dang, that's messed up, but yay. You know what I mean? It's one of those things, man. So I know that it was just pretty lit to see that happen, man. Appreciate the hard start, man, as well. But yeah, it was dope. I enjoyed the whole process though, for sure. Just doing it with you guys the whole entire day and the build up to it, the intensity of it. Like, you know, anybody care to explain how they felt when their name didn't get pulled? You know what I'm saying? When you felt like you like, how was you sitting at the edge of the seat? Cause like y'all gotta know, like I know a lot of y'all was like on the edge, like, oh, is it my name? Is it my name? Especially when I started calling. You was like, dang, my phone ain't ringing. Why my phone ain't ringing? You know what I mean? So it's just one of those situations, man, that I feel like it was great. It was great to be a part of for sure. And here we are with another opportunity. So the drawing will be this coming Saturday, right? So you still got time. If your name was already pulled for the cash prizes and other things like that, you still can enter back into. Anybody can, just so you know that. All right. Just to put that out there to you guys. But the conference is definitely going to be super lit. All right, we're gonna hit this record button and we're gonna see what you guys on today. Let's talk about some stuff. Got a lot to talk about, for real. People be forgetting, boy. So, welcome to In God We Trust Academy, the Lawman podcast. This is episode 19. As always, we appreciate for everybody that comes in, show their participation, show the love, etc. And to make this what it is, all like-minded people are here, and we're here to grow. We give thanks to the Almighty for this present time, for everything that is taking place to allow this very moment right now, and still that we have the freedom of choice. Right? Everything that it is today is because of our freedom of choice to choose to say yes, no, to consent, to not consent, to withdraw or participate, etc. Right? So here we are, man. Here we are. And it's such a beautiful thing to be able to have that, right? What would life be without a free conscious state of mind to say yes or no? Like, what if that was taken from you? Would you still feel the same about you or freedom? And if that's the case, if that's taken from you, you wouldn't even know what freedom is. None whatsoever. All right? It wouldn't even be a thing to you. It wouldn't even be defined to you because you wouldn't have the freedom of choice just to say yes or no. And that's one of the things, especially since looking at my beautiful daughter, like she'll say mm-mm or yes. So that's a beautiful choice to always be able to have. You know what I mean? And that's powerful. So let's make sure that we act righteously in that choice and make sure that we can, hold ourselves accountable for those specific things as well. Everything that you guys hear from this point forward is for education and religious purposes only. So anybody seeking any form of legal advice, please do see a legal advisor. We got any testimonies before we push forward? Anybody got a testimony today? More than welcome. All right. What I will say is this. We've been sitting here for the past few days. Even last time we was on here, we talked about a lot of stuff, but I'm just going to continue to keep showing y'all. I think that's the best thing is to show you, right? Keep just showing you what the law. Let me ask you guys this, because a lot of y'all been on this journey for a minute. You've been here, there, this class, this whatever, studies, reading this book. What do y'all feel about the method that we are utilizing here today, especially with anything that's pertaining to the Lawman series? Because everything everything that we're speaking on is it's not a guess, it's not a theory, it's not you wondering where it comes from, where can I find it in law? Everything is pointed out in relations to law and how to exercise that, even according to the definitions that the law uses today. What are y'all feelings on that? Oh, y'all talking to me today. Go ahead. Talk to me, Jen.
Well, I think I just feel so much more confident because it's in black and white. It's the law. There's, like you always say, there's no theory behind it. And I'm finally to the point where I also feel like it helped me to understand capacity and just really everything is falling into place because of this, and it's taken a really long time for me, but I'm just so thankful. Like, you have no idea. I just got married in April.
Congratulations.
So now we have our family. Thank you. So now we have our family. Thank you. We've been together for 13 years. So it's a crazy testimony for another day. But we're finally together, and I feel like God's just been pouring out his blessing, nurturing our family trust just based off of everything that you've taught. And, I feel like I've just made an investment over the last 3 years that I'll be able to keep forever to look back on. But the Lawman series, I'm looking forward to this conference because I feel like the timing is amazing because not only have I created the trust, but I've structured a holding company and some divisions under that as well. Just how it's making sense to me. And but the fact that it's all just the law it's just freeing. It's just mind blowing to me that I have so much peace. And I wanted to also say, I didn't speak up last week at the end. I felt like I should have, and I'm not bringing anything up other than to say that, I've been doing this since 2022, like seriously. And I can remember when I came across your page, it was late at night. I'm in Ohio, and it was 2023, July 2023. And you were in this, I think maybe you were even sitting on the floor by your bed or something. And it was just like a yellow lamp, and you were just talking, and I just knew. It was like God said, you need to listen. to this man. And I've been listening ever since. And you guys are just such a blessing. I was probably drunk for the first year that I listened to you. As a matter of fact, I asked you a question one week, and then the following week I forgot that I asked you that question. That's so embarrassing to say, but it's part of my testimony. And I just said, you know what? God was like, you really just need to sit there and be quiet and listen. And so I haven't had a drink since September 1st, 2024. Also, because July 2024, I remember you, thank you, saying that if you're listening to this, you're here for a reason. God has you here for a reason. And I mean, I just feel like it was just part of me waking up. And in 2013, the police broke my wrist, and I was never in trouble before, ever. And they ended up arresting me and holding me overnight. The next morning, they called me by a different name, gave me a sentence, but then I was still there at 5 o'clock. And the next day, it was almost like double jeopardy. I've just always known something's not right. So I don't necessarily have anything I'm working on now. I mean, I will be coming up, but it's just been a long journey, and I'm very excited to hold on, baby. Okay, let's go. I'm excited to be here, and I also want to say that you motivated me when you started saying you guys are going to start talking or listening, or else you're not going to be in here. I was like, oh Lord, please help me, because I'm so shy. But I wasn't going to let that stop me either. So I appreciate that push, because I didn't want to be embarrassed either. And yeah, so it means a lot to me, Eric and Nikki, and you guys mean a lot to me. And just thank you for everything.
Absolutely. Appreciate you. Appreciate you for that testimony, as it is, for sure. And the reason why I asked this is because, again, guys, like when I speak to you guys, I want y'all to know, especially people that just coming into, this whole journey, you want to get into status correction rights. Like, I'm not speaking for somebody who hasn't done anything. I'm speaking from a place who went all the way through it. I can tell you the books that's going to be circulated in that community. If you just join in that community, you're gonna get a certain amount of particular books that's gonna be directly given to you, right? And everybody in here has ran across it at one point of time, right? And I guarantee you, a lot of y'all will start. What is it? Concise West Trustee book. You will get that one eventually. You'll get something of in relations to A for V, the validity of A for V. You'll get one of those books. You also get the book with Uncle Sam on it. What's that called? Zero something. You end up seeing that come across.
0%.
Yeah, you're gonna see all that shit. And I'm telling you, that those been around for a long time and has not been sufficient enough to stand in court with any evidence. But they float around. I just want you to understand that. So, like, we know, we've seen them, we've read them. A lot of it is great. But what I had to start realizing is this: it's so much outdated information because things have changed due to a lot of ways, especially when it comes to citizenship, because of the Reconstruction era that happened, right? Those specific things take place. But we speaking from a place of experience and then being able to win. A lot of people comment on my stuff, and it's like, hey, once somebody's like, well, all statutes or statutes is not law. And I was like, that's not true. A statute is always considered to be law as long as if it's in pursuant to the Constitution. If the Constitution authorized the legislature to define this through legislation, and it's when they defined it's still in line with the Constitution, then it's law. It ain't like you can't just discredit it all just because it's a statutory law. And I can show you the difference. I can point out to you what statutory law goes against the Constitution, etc. We've done that plenty of times in here, but not every last one of them do that at all. And a lot of things that's written in statutory is for convenience. It's to see if you're going to even waive a right that you might have, right? Literally, someone said, "Hey, when you get driver's license, you automatically waive the right of due process." No, you don't. That's stupid. Nothing waives due process. It doesn't automatically waive due process because you got some driver's license and stuff like that. Y'all be coming up with stuff that you cannot freaking prove. None whatsoever. And this is why I say, like, you got to be able to go into court. Now, he showed the driver's license, and on the driver's license, it said that if you have a driver's license that you consent to anything to deal with like DUI. You know what I'm saying? Which, okay, that's kind of understood, but at the same time, there's still due process that still has to take place. So they can't just pull you over and then make you run a full DUI situation when they have no probable cause to think that you're driving under the influence. Do y'all understand what I'm saying? That still deals with due process. So they just can't pull you over and start giving you tests and stuff. That's due process. But if they have an actual probable cause to do these things, then that's so. But just because they run the situation and do it still don't make it legal. It does not. They still can mess up. They still can do things that in the process of giving you this test, they still violate it. So just because they gave it to you don't mean they have an actual probable cause to start it in the beginning in the first place. See, this is what matters. Reading it. Reading is definitely fundamental. So check this out. Let me show you guys something. I'm going to read this to you. And this was in the Black's Law 4th edition, right? Go get the 11th edition or the 12th edition, whatever one's out today. But here we go. See, here we go. Somebody else saying legal statutes are not law. Okay, go break one. I'm tired of y'all saying that stupid shit. So everybody that feel like they want to say that, go break one. Literally. Go out there and go break a statute and prove to us that you ain't finna go to jail or anything like that else behind it. To say statute is not law, so what about where the statute talks about how a warrant has to be presented? So that's not law? So now you can't use that to go into a particular courtroom to literally challenge the due process, the procedure of it, of how the warrant was obtained? Well, it's written in statute, so therefore you have no way to say how a warrant is to become active, who's supposed to sign it, etc. But that's written in statute. It's not written in the freaking Constitution. That's the point of having to define it. See, those who say this, if you don't understand what a self-executing clause is and a non-self-executing clause, any non-self-executing clause, right, has to be written in statute. It has to be further defined. No way around it. If it does not self-execute. Now, we talked about this last time. Y'all know what a self-executing clause is, correct? Remember, it's something that says that you got to be a certain age to be the president. That's a self-executing clause, right? But there are clauses that still have to. So here we go. I don't even see. Here's the thing about using Black's Law. Black's Law cool, but guess what Black's Law say? Hey, you need to go refer back to the federal laws and the state laws to make sure that what's in this dictionary is aligned to what is modernly said today. See, this is what I be saying. But listen, don't ask me have I looked up this information. Go do what you said. Since it's not law, go break the freaking statute. Go find you one. Pick it out. Get on camera. Show it to everybody. We want to see. Otherwise, it's easy for y'all to get on here and comment this bullshit. What's up, Ricardo? Talk to him.
So I just trying to get an example in my mind. You're talking about self-executing clause. I'm trying to just see, right? I made a trust for my sister, right? A ministry trust, and I did a bank account. While I did the documents in the bank account, I made it as the only other person would be her daughter, which is like she's 4 years old now. Now the self-executing clause, like now if I'm thinking about it, was if she turns 18, now she has same rights and interests as what the mother would. Right. That's okay. Cool. I was making sure that's what I meant.
It needs no further to be defined. So that means now you don't have to go and define that more in a trustee resolution. You don't have to do that. It's already self-executed. That's the same thing when it comes to the Constitution. The same thing. Now, listen at this. It says this need to provide legal services was recognized by Mr. Lewis F. Powell, Jr., president of the American Bar Association, 1963-64. Look at what he said. He said, looking at contemporary America, realistically, we must admit that despite all our efforts to date and these have not been insignificant, far too many persons are not able to obtain equal justice under the law. This usually results because their poverty or their ignorance has prevented them from obtaining legal counsel. So they already said that, one, you don't got the money, and or you don't even have the knowledge to know that you even being harmed. That's America. They also said a wide gap separates the need for legal services and its satisfaction. As numerous studies reveal, looked at from side of the layman, one reason for this gap is poverty and the consequent inability to pay legal fees. Another set of reasons is ignorance of the need for and the value of legal services and ignorance of where to find a dependable lawyer. There is fear of the mysterious processes and delays of the law, and there is fear of overreaching and overcharging by lawyers, a fear stimulated by the occasional exposure of shysters. So why are they saying that? Let's dialogue on this. How does that make y'all feel hearing that? Anybody?
You can't trust their words.
Meaning?
People start taking matters in their own hands.
What'd you say, Richard?
People really got to start taking matters into their own hands, start informing themselves, and so they could cure that ignorant spell, and they don't have to pick out for the representation because now they can go pro se.
All right. What you say, Great Ike? I didn't finish hearing what you said.
Meaning you got to look out for yourself.
But it also what you do, and that's true. But basically, what it just said, it says, hey, the average, it's basically saying the layman, which is the average American, the masses of the people, they don't even know when they need legal services. So swap that word around. They're just saying you don't even know when you've been caused harm. You see what I'm saying? They basically saying you don't even know to even come to us or when to come to us. The people don't know the law at all. So since you don't know it, here we are. You're going to suffer for it. And then not only that, the fact that you don't know it, they saying, hey, there's some lawyers out here that are shiesty. They some poo shiesties out here. That's what they just said. They some shiesty lawyers. And they gonna rob you blind. Cause they aware you don't know. This is why they are slang all these little pleas and stuff at you and just take your money just to give you a 15-year probation, 10-year probation, something like that. You have to understand what they're doing. A lawyer will say, hey, they dropped the felony down to a misdemeanor. Yeah, we're gonna ask that you take this. Boy, what? You charged me with a misdemeanor? I mean, a felony, took me to jail, did all this, and then you want to drop it to a misdemeanor for me to accept? See, a lawyer, no, that's bullshit. Because your probable cause that you took me to jail for was the what? The felony, not the damn misdemeanor. That misdemeanor has to be a what? A probable cause to stand on its own, correct? You can't correct a charge after you done charged somebody and took him to jail up on that charge. That's not a defect in the case that you get to change. What happens is there's no evidence. Now you lose in what? Jurisdiction. None whatsoever.
There you go.
So this is a thing. And this is what they saying. If you don't know, now you know. You better know something. Because if you don't know something, they finna take something. Yeah, they finna take something. First being your money. That's the first thing they gonna take. Mm-hmm. So it's like you have to understand that like ignorance of the law is inexcusable. And I watch so much crazy stuff. Like I posted literally the other day that, hey, the Black's Law Dictionary said, hey, you need to take these definitions and align them up with today's law. And whatever today's law say, it supersedes what's in this dictionary. So let me explain it to you like this. If you read in a dictionary that it once said human being means a monster, well, when you go read the federal law and you read what human being says today, it supersedes that what it meant in the past. Do y'all understand that?
Gotcha.
Yeah, it does. And then somebody say, well, can you show me where in the Constitution it says that they have the right to do such and such? Yeah, it says they have the right to legislate. To legislate, that's what it means. You understand what I'm saying? They have the power to legislate. And we got the power to what? Amend. According to the Constitution, we got the power to amend the Constitution for whatever reason that we need. Doesn't matter. But see, now y'all got to start identifying things. When it comes, if you want to say a statute don't apply to you or something, then you got to understand what does your conduct reach the specific elements of what they trying to charge you with? If it do not, then it does not stand. It's very simple, right? And I keep saying this too. I keep saying this to people. We win cases over here. Do we not?
Say that again.
Do we not win cases, y'all? We win.
We do.
We win with what the fuck we talking about. So why is it that y'all want us to change up something that y'all ain't show no proof of winning with the shit y'all saying? How do y'all?
Got no proof.
They ain't got no proof. They just get on here and talk. We win. This is what we trying to tell y'all. We win. So what do y'all want us to do? Stop utilizing the law that we're actually kicking their ass with? Stop utilizing the rules and procedure that's making the court run smoothly like we wanted to move without being called sovereign citizens and getting our documents ignored? Y'all want us to run and do the shit y'all do. And y'all mad because we winning. This is the thing. Like, so I will never stop doing something that is letting us win. Oh, we went from y'all perspective. They hit us with the sovereign citizen. They hit us with the ignore the documents. They hit us with the we ain't showing you ain't showing up to court. You got your four corner rule, etc. Da 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 da. Yeah, they hit you with the failure to appear. See, how is it you gonna say you have a right to be heard, the opportunity to be heard? How are you going to literally not go exercise on that right? Now you choose to waive it. Now you just told somebody that's in a civil claim that needs to show up to court. And if they don't, they're going to fall into default. But you just told that person don't show up. Damn. What you think about that, Great Ike?
I think people just make it harder than what it is, man.
A true law cannot be changed by legislation. We never said that. We said what we said, meant what we said. You have a hard time of hearing. That's what it is. You have selective hearing. I don't even think it's selective because we ain't even saying shit to say what you saying. You just talking. It ain't even selective. You still ain't answering my question though, because I really want to know. So I want everybody to go follow the great Yoda. We're going to watch him go commit a federal a felony. Make sure it's federal. Go do that by statute and show us how it don't apply. I'm still waiting on somebody to do that shit. And when we get to talking like this, for them to give us a prime example. Because if you show it and prove it, I'll follow you. Everybody else will too, won't y'all?
Yeah, that's for sure. Yeah.
Hell yeah.
So show it to us.
No.
Show it to us. I don't want to see another comment, nothing. Show it to us. Please do. We want to see. Anybody else that's been commenting in my stuff or whatever, I want to see. Show it to me. Show me you can do it. Because half of y'all just sitting at home and damn near ain't even got a car. Didn't even talk about right to travel. The fuck? Let's just be honest. Y'all catching transportation to work and shit. Yeah, so that is your right to travel. To hop on a train, to hop on a bus, to hop in an Uber. Then they'll hop on here with y'all and try to say and argue and all this type of shit that they saying, and you ain't got a car to talk about what you're saying. So that's why, like, for real, get on a video camera and show us you getting in your car and go and do this all day. Run into all the flock cameras you can and do all this stuff that y'all doing. Make sure they pull your ass over. That's what I'm saying.
Take a video of that. Send it. Yeah.
Send it to us so we can dialogue about it. Like, you know what I'm saying? This is a class experiment that we want to say happen. Y'all keep wanting people to go down that road and suffer and all of that, but you ain't nobody gonna help no damn body. Most of y'all that say that shit when it goes down, ain't none of y'all gonna do that. I don't need to look up nothing. You talking to somebody that's then beat all the right to travel situations. Beat it myself. I done want every traffic case I done had. Have I not, y'all? I've been very transparent with y'all.
Amen. That's true.
Literally watched them take my truck. I had private tags, everything. Watched them take everything. Went in, still had me a shot and a drink. Went home, came in, got on live with y'all, right? It's on YouTube right now. You can go look at it.
Yep.
I won. And guess how I won? The law, rules, procedure, everything of what the fuck you not saying. That's why I be saying y'all be coming on here talking to somebody who winning. What you want me to do? Use what you said? How about the stuff that y'all saying? These are the clients I get saying that they took and listened to somebody saying some shit like that and didn't get no remedy. And then they said when they started getting ready to go to jail, y'all poof, y'all disappear on them. Y'all gone. Y'all gone. I say, what happened to your mans? Man, I don't know, man. They ghosted me, man. Took $1,500 from it. Told me I was dumb. I don't read. Hey, bruh. How many times y'all done heard that? Seriously.
Over and over again. Over and over.
And then again, everybody in here, we all speaking from what? Experience. Are we not?
Yep.
We know. So I don't understand what y'all be wanting me to run with a theory that y'all have. I'm cool. And the thing about it is I actually, as of right now, I'm so solidified in my foundation that I know what I'm standing on can't be shook. I don't even got a question because I'm going to go directly to the law and I'm going to apply it. Exactly what it said. Because what? You got to understand that literally the law is a binding command. Right? It's a binding command to control an outcome. So why would you not use words that binds? That's a binding command that controls an outcome. You're in control of it according to the rules, the words, etc. that you are using. If you use any words outside of law, do you think they got to hear it?
Nope.
Nope.
They don't got to hear it, do they? It's only 2 books that I've been reading from the past 2 months. One is The Foundations of Law and Volume 1 and Volume 2. And then some of Volume 3. But really these 2. How many of y'all got the Lawman series? Anybody in here?
Check. Yeah, you threw me there.
I'm going to go on and get you up out of here, buddy. I'm going to let you do your thing. Because if you ain't talking about being a class experiment for us to see you go and commit this felony, it's about time for you to go. Because you saying all this shit, you ain't proving nothing. You know what I'm saying? So let me help you on out of here, buddy. Let me help you on up out of here, buddy. Go jerk off somewhere else. This ain't the place.
Word up.
Yeah, this ain't the place. Get on up out of here, buddy. All right, so let's start this right here. Definition of procedure. Procedure consists of the mandatory legal conditions precedent that must exist before a court may lawfully exercise power over a person, a claim, controversy, or a remedy. Man, that is powerful. So what does that say to you? In that first sentence, something has to happen first before, right? Before a court may lawfully exercise power over a person, a claim, or controversy, or a remedy. So they can't even give a remedy. They can't grant relief. They can't have power or any of that unless something takes place first, which is procedure. Now, how are we going to know procedure, family? Can anybody explain that to me? How are we going to know procedure? There's only one way to know.
We gotta look for it. We gotta read it.
We gotta read it, don't we? We gotta read it, don't we, fam? Yeah, I heard what Monique said. We gotta read it. We got to read the law. What does the law say that is required in this particular procedure for the court to have the power to adjudicate the matter? If procedure was done wrong, court has no power, right? It says these conditions are not discretionary, are not subject to waiver by judicial preference, and are not cured by presence of meritorious facts or equitable considerations. Procedure operates as jurisdiction in motion. Listen again. Procedure operates as jurisdiction in motion, transforming abstract judicial capacity into case-specific authority. So that what happens is this. If something takes place, there has to be a probable cause, which is part of procedure, which gives a form of a particular jurisdiction and what they want to charge you with, right? Now, this probable cause, et cetera, has to come from some source of authority in relation to a statute. And if it is a statute, that statute has to be still in pursuant to the Constitution, which the legislators was given the power to legislate over this particular subject matter. Everybody understand that, right?
Yes.
Gotcha.
Okay, so now probable cause happened. They pull you over. Hey, we still got it. They still in line. All right, now what they do from this point forward in dealing with you, if they snatch you up out the car without anything else, they just snatch you. Like if they gave you a speeding ticket and then boom, they snatch you out the car and start searching. They just violated what?
My Fourth Amendment right.
Which is what though? What we talking about today?
Procedure.
They violated procedure. Due process. Which is due process, exactly. So as soon as procedure is violated, now, do the court have the power to lay a claim? Absolutely not. Because when you get to this court, you have a duty to do what? We're going to challenge the procedure. Right? We're going to challenge the procedure, due process. So there's a defect in procedure and due process, which now makes them lose personal jurisdiction. They have no power over you to bind you to the court. They might have subject matter because subject matter just means that this particular statute, this court has the power to adjudicate this particular charge, right? It's within its jurisdiction, right? It has that power. That's all that means. Territorial, did it happen within that particular entity or court's boundaries? Right? That's it. Personal, that deals with everything else. And then guess what? Subject matter is a judicial situation. They have to answer too. So everybody always trying to make the court answer to something. The court don't have to answer to anything but subject matter. When it comes to personal, et cetera, well, now you gotta prove that the prosecutor or the prosecuting, the prosecutor, the plaintiff, whoever has the power to do and bring what they have, right? But it's also your proof to show the defect in the actual case. If you do not show the defect, here's the problem. Okay, so understand, procedure operates a jurisdiction in motion, transforming abstract judicial capacity into case-specific authority. Until procedure is satisfied, a court remains inert, lacking power to bind parties, adjudicate rights, or grant relief. The controlling rule is that a court may not reach the substance of a dispute unless and until procedure has been satisfied in full. Procedure determines whether a case exists at law, whether a party is properly before the court, whether a claim is cognizable in that form, whether defenses are preserved, and whether relief may be lawfully granted. You can't bring a $20,000, $30,000 claim against somebody in a small courts claim. So now you don't have the power to bind that person to their court. And that court lacks what? Subject matter jurisdiction, because they don't have the power to hear a case of that amount. They can't even grant relief. Sometimes they can hear certain things, but it's the relief. And if the court doesn't have the power to grant relief based upon what you ask, then they lose jurisdiction. They can't do it. Not supposed to be there. So it depends. It depends. Okay? So now, substantive law defines rights and duties, but procedure determines whether those rights and duties may be adjudicated at all. No amount of factual correctness, moral force, or legal validity can substitute for compliance with mandatory procedure requirements. So if there is supposedly a warrant supposed to be out for a warrant for your arrest, let's just say that. Someone comes to your home and then they say, hey, we got a warrant for John H. Doe. Is he here today? Is he here with you? And you'd be like, look, no. And even if he was, you still can't come in here. You gotta catch John H. Doe on your own. The thing is if you're going to go look for him at a specific place, see, if they don't have the house, the address, etc., directly on there to go specifically there, do they meet the elements to literally go search? To go serve that warrant?
No, they're missing information.
And that's because of the elements. So that's part of procedure. See, but people want to get rid of the statute, which gives you the procedure that is required for the elements to take place to charge someone with something. But no, we don't want to listen to the statute. Okay, well, don't use it. You understand what I'm saying? Like, how you going to get your remedy if you don't use the rules of the court? How you going to get your remedy if you don't use the statutes that are enacted and pursuant to the Constitution? Can anybody explain that to me? I've done enough work to know that you can't. Anybody else feel different?
I think you just put a 1099 on top of another 1099 and just do some other shit, make it work.
Hey, you know what? You know what I had to realize about that too? Like, if you're gonna say this is a tax court, you gotta prove it's a tax situation. Who's getting the income? What money's involved for there to be any form of income, and then you gotta prove where that money is coming from, what account is related to. You're gonna have to have somebody with firsthand knowledge as a witness to specify they know the entry of this account, the credits that are there, etc., or that is considered to be income, and this is a tax issue. See, you gotta prove all of that shit.
Mm-hmm.
You got to prove it. And tax stuff, there is a tax court literally specifically for this specific situation. So if you have a taxation situation that's being dealt with whatever, then take them to tax court. Have anybody done that yet? Y'all heard anybody done that yet?
Nope.
You know why they can't do it? No evidence. No proof. No admissible evidence. And that's the thing when it comes to these accounts, records, and stuff like that. You're going to have a witness with firsthand knowledge. So here's the question. Since you're going out to the Federal Reserve, can you get somebody that as an employee that works for the Federal Reserve to literally be a witness on a specific account that you speaking on, that you saying to hold some type of money? Can you get that? Because if you can't, then it's a waste of your fucking time. Because it takes what? What does it take, guys? Evidence, right?
Correct.
And evidence, etc., is also part of the procedure. Procedure is that you need to have evidence according to your claim. You just can't come up here saying anything with no proof. So when you go in here, and no matter whether you put it, assert it in an affidavit, etc., that's why they'll answer you and say, yeah, that's sovereign citizen talk. That's already been played. Here, look at case law, such and such, such and such. Boom. The judge going to look at it. Yeah, you're right. Case dismissed. Get them up out of here. It's gonna happen that fast. Like, I'm telling you from experience. But ever since I let that shit go, boy. Win. They settle. They don't even want to go to court. They'll settle out of court. I done had people get charged with felonies, major felonies. 10 years, about to let them 10 years, right? 10 years in jail. They looking at, and I said, yeah, your conduct don't match that. Let me send them this, and according to the law, we did this. And then they said, hey, won't you take this misdemeanor? And we was like, yeah, even if we wanted to take the misdemeanor, you don't have the elements here to charge, even with a misdemeanor. So we can't accept that either. What y'all think the prosecutor did then? Gone. Poof. Gone. And why would they take something that is a felony that has to be taken to a grand jury indictment? Why would they try to knock it down to a misdemeanor? Why? Because they know they don't have enough evidence. And trust me, that bond in their case will be a higher case than it will be a misdemeanor. So the only reason they're going to move it because they never had it in the first place. Procedure must be distinguished from substance, rules, and policy, as conflation of these concepts is the primary source of attorney error and adverse outcomes. Substance concerns the existence and content of legal rights and obligations. Procedure concerns the authority of the court to adjudicate those rights and obligations. A right that exists in theory but is asserted without proper procedure is legally non-existent for purpose of adjudication. Oh my God, do we need to say that again? That's literally what we've been saying to y'all. Right? If your right only exists in theory, but is asserted without proper procedure and is legally non-existent for the purpose of adjudication. That burned somebody's soul right there, didn't it? Rules, by contrast, regulate conduct within a proceeding and may be subject to judicial discretion, harmless error analysis, or equitable relaxation. Procedure is not subject to such discretion at all. A violation of a rule may result in sanctions or corrective orders, but a violation of procedure results in the absence of jurisdiction or authority. And if there's no jurisdiction, there ain't no authority. Policy represents judicial or legislative preference regarding outcomes, efficiencies, or fairness, but policy cannot enlarge judicial power beyond that granted by Constitution and statute. So when policy conflicts with procedure controls, not because it is preferred, but because it defines the outer boundary of lawful judicial action. So when it says that basically you have the right to, due process, equal protection of the law. And the only way to do that is to establish court rules and procedure. So without criminal rules and procedure to be established to make sure that the fairness of the trial and case is definitely enforced, then you're wasting your time, guys. If it wasn't there would not be any fairness in court. But see, the only thing that becomes, I guess you would say, unfair is because there's an incompetent individual and there's a competent individual. So who gonna win the case?
The competent.
Every single time. Even if the incompetent know everything that they saying is true. But if you get in there and you can't move the court, you can't go through discovery to get everything that you need. You don't understand admissions, interrogatories, etc. Because for some reason, everybody just thinks that no court has no jurisdiction, none whatsoever. What happens when they all align? Because you might not have, if procedure was properly done right, if, certain things, etc. But then you might not be able to find what you're looking for until you get into discovery. Yeah, they might say they have, we charge you with this, and that. Then when you get to court, we don't have any evidence to provide you for discovery. What? You know what I'm saying? You said what? Like, yeah, did they have territorial jurisdiction? Yeah, it happened in there. Did they have subject matter, the right to charge you, or the court has the right to hear this case? Okay, yeah. Now we got personal jurisdiction, meaning at this particular time you still have it because, okay, you're charging me with this. I don't have any preliminary motions at this particular time, so let me just say not guilty because I know I'm not guilty, and I'm going to ask for the evidence. So now that we're going into this particular court, all right, here we go. You can say not guilty and ask for a trial by jury. Anyway, as you go through, now we got discovery. So when we get in discovery, you request it, and they say, hey, we don't got it. Or they don't say anything. Let's just say you requested, they don't say anything. So after you request it, they don't say anything. What's your next move? What's the procedure for that? Anybody? Request special appearance? You don't request special
Motion
appearance.
to dismiss.
Motion to dismiss? No, you don't do a motion to dismiss. But we're gonna get there. That's a premature.
Compel.
Motion to compel. Now we're going to motion them to compel. To compel. We're gonna make the court do it. Because we need discovery before we can move on to getting ready for to prepare for trial. There has already been a date set, so we got this amount of time to do this, right? So now, once we go through this, they don't provide, then we do a what? Motion to show cause. Once we do a motion to show cause, then we can sanction. They don't show cause, we sanction. Now you move for the court to dismiss the case for lack of evidence to prosecute. See, this is what it happens. But now let's say that you do a motion to compel. And let's say the judge ignores that and goes straight into the trial. Now, you got to ask yourself, is that following procedure in the rules of the court?
Hell no.
Right? So if the court continues and let's say they do a full judgment, you got to ask yourself, did the court lose jurisdiction?
Of course.
It does not have the power to stand and give a judgment at all because it's violating the fairness and procedure of the court. So now you have to you can object, you can make them have it, do an objection of it, do a judicial notice, apply it to the rules and procedures of the court, hold the judge accountable, give him an opportunity. If he do not, what's our next move?
Writ of prohibition.
Compel motion.
Writ of mandamus.
Yeah, we're going to do a writ. We finna get a remedial writ, and we finna go do it and go to a higher court, and we're going to prohibit them from moving any further until they have a hearing on this particular motion. Right? See, everything we said is equity. Everything we're doing, we're utilizing it to receive equity and equity just means what's fairness. We want fairness. We want what's right. What should have been done. What ought to be done. That's what we want. So to remain in those places, guys, you have to be alert. So that's why I say when people tell you, hey, don't read the rules and procedure. Don't do this, don't do that. Listen, you're losing your rights. You're losing your right to exercise these things to get your win, to get your remedy. And the further you keep removing yourself from the law and not wanting to utilize the law, then you're going to continue to keep removing yourself. And there are so many other things that you can do as well. But you cannot take people to the water and make them drink at all.
Can you explain the writ of mandamus?
It's to mandate the lower court to do something that they're supposed to do. So that means that a higher court, acting as a supervisory court, supervises a lower court to do a duty that is supposed to do by law. So they can't skip to a trial when there was a motion here and they have to have a hearing on that. So the court says that pursuant to this procedure, et cetera, they have to do it.
Got it. Thank you.
Yes. Rules, by contrast, regulate conduct within a proceeding and may be subject to judicial discretion, harmless error analysis, or equitable relaxation. Procedure is not subject to discretion. A violation of a rule may result in sanctions or corrective orders, but a violation of procedure results in the absence of jurisdictional authority. Policy represents judicial or legislative preferences regarding outcomes, efficiency, or fairness, but policy cannot enlarge judicial power beyond that granted by the Constitution and statute, right? Understand that. So, source hierarchy of procedure authority. All procedure derives from a strict hierarchy of authority that governs the existence and limits of judicial power. So at the highest level, the constitutional provisions create courts, define their jurisdiction, and impose non-waivable limits on their authority. Listen at the next word that's going to be said. Statutes enacted pursuant to constitutional delegation prescribes the specific conditions under which jurisdiction may be invoked and exercised. Now, what does that mean to you? What does that mean to you?
It's law.
Who said that? It's law.
Here.
Oh, okay. All right. Yeah. I got to talk to you later. So yeah, it is though. And it's just literally saying, hey, as long as it's what? Pursuant to constitutional delegation. So what does that part mean? Constitutional delegation. That literally means that in the Constitution, the legislature is giving power to legislate over a particular subject. Understood? Now,
Yeah.
just because they've been given the power to legislate over a particular subject doesn't mean that they get to what? Write some legislature about this subject that cause a conflict of chain of command with the Constitution. Because where is the source of authority? That's just like I showed you guys. In Alabama Constitution, it says that the right to a trial by jury shall remain inviolate. But when you go read the statute that creates the court of a district court and a municipal court, it says that those particular trial cases will only be a judge without a jury. So now they got to show what authority, what source of authority from the Constitution says you can do this. There is none, because in the Constitution it says, hey, it shall remain inviolate. It shall never be violated. So now it's your duty to recognize that and say, hey, this court does not have what? Personal jurisdiction. It does not have the power to bind you to it because it cannot give you a right that's protected by the Constitution. It cannot protect it. It's taking it away from you. So you got to raise the issue about it. So that's what that one would be. But anything else that's in line with it, it's law. Court rules operate only within the scope of authority granted by the Constitution and statute. So now you have to understand, court rules even derives its authority from Constitution and statute and cannot confer jurisdiction where none exists. Cannot do it. But the only way you gonna know this, guys, is if you what? You're reading these things. If you're not reading them, how can you expect to understand procedure, to even be able to challenge it or anything of that nature? It's not going to happen. It's not going to happen. You definitely going to take a L, right? Custom, practice, or local habit has no legal force in conflicts with or attempts to supplement mandatory procedural requirements imposed by superior law. So any procedural analysis that begins with rules or customs rather than constitutional or statutory authority is structurally defective. So they just told you it has to derive from the Constitution into statutory authority into the court rules. Even if it's a policy has to be travel up the chain of command. Does this particular policy go against the Constitution or even a statute at that particular point. If it don't, then it's lawful. If it violates, hey, we got to check it. But it's your duty to check it, because otherwise you choose to waive a right and not exercise on something that you have, right? Thank you for the follow. So this is serious, man. Do not go out here trying to do anything without reading and having a real understanding of the law itself. It is a waste of your time. Right? I'm serious when I say this. So, procedure as a mechanism that creates authority. Judicial authority does not exist in the abstract and is not activated by the merge of filing papers or appearance of parties. Now, how many people tell you that if you appear, automatically they got a jurisdiction over you?
Say that one more time.
Like it just said, judicial authority does not exist in the abstract and is not activated by the mere filing of papers or appearance of parties. And people always say, soon as you show up, they got jurisdiction over you. No, they don't.
Oh, I heard that line plenty of times.
And that's the point of what? Special appearance. But a special appearance, you don't necessarily have to write, I'm doing a special appearance. I'm doing a special appearance to do a motion for request of discovery. That's not a special appearance. Special appearance is to challenge a defect in jurisdiction or procedure, etc. That's it. A general appearance is you showing up to answer to the court by an answer in an affirmative defense. And then you moving forward into procedure of the discovery. That's different. Definitely different. So, authority arises only when the precise procedural conditions established by law have been satisfied. Proper commencement of an action invokes the court's power over the controversy. Proper service of process invokes the court's power over the person. Proper standing invokes the court's power to adjudicate the dispute. And proper charging instruments invoke the court's power in criminal cases. Proper timing preserves the court's authority to act at each stage of the proceeding. Timing matters. Each procedural step functions as a gate. Failure at any gate prevents authority from passing forward, and authority that never passes forward cannot be retroactively supplied. Loss of power despite subject matter jurisdiction. Right? Now, the first thing, again, what you have to remember, if you're going to challenge jurisdiction because there's a defect in the case, then show proof. Say, hey, here's a defect. Here's why I'm challenging. The burden shifts on the actual prosecuting party. They got to show it. If they can't, dismiss. We up out of here. Subject matter alone is never sufficient to sustain judicial authority. A court may have jurisdiction over the class of cases to which a controversy belongs and still lack authority over the particular case before it. Improper commencement, defective service, absence of standing, failure to comply with mandatory deadlines, or non-compliance with statutory prerequisites all prevent authority from attaching, even when subject matter jurisdiction exists. So they might have the power to hear the charge, but they don't have the power to bind the person. You understand what I'm saying? Yeah. Jurisdiction over the subject defines potential power. Procedure determines whether that power may be exercised in a given case. Confusing these concepts results in false assumptions that a court's general competence cures procedural defects, when in fact those defects deprive the court of power altogether. So, relief is not an inherent function of courts, but a conditional consequence of properly invoked authority. Before any relief may be granted, the party seeking it must establish that jurisdiction was lawfully invoked, that all mandatory procedural requirements were satisfied, and the authority existed at the moment relief was sought. Failure to meet any procedural condition precedence precludes relief regardless of the merits of the underlying claim. Courts cannot grant relief they were never empowered to consider. In any order of judgment issued without satisfied procedure is subject to direct or collateral attack. So let's say that it's a small claims court. They make a claim to you. You didn't show up to court. You defaulted. And then they start garnishing your check, right? And you find out from your employee the specific case, et cetera, and the order that was given to do this, right? And once you read it, you say, hey, I wasn't properly served, right? So now the court that never had power to grant the plaintiff any form of relief. So now you got to go do what? Move the court to vacate, right? And if you don't use that procedure, guys, you ain't going to get it. So the rules and procedures of the court, go do a motion to vacate. That is equity. For those who don't understand, that's equity. That's fairness. You want to vacate it for improper service. The court has no jurisdiction to bind or to even grant a relief because the procedure was not done correctly. And now you want to also place in there that you want what? All your money that they garnish from you. And then you can also put in a counterclaim because you suffered on the damages of them bringing a claim that they never had authority to do. Never. So what damages did you suffer when you found out they took your money? That they took your money. Right? Was you late on rent? Did they come take your car? That was your last payment you were supposed to, whatever the case may be. They took your car, your lights went out, whatever. All of these are damages. Punitive damages that you get to calculate up. Right? Absolutely. The mastery of this chapter enables the reader to understand why courts routinely dismiss substantively valid claims and uphold substantially defective ones, why arguments grounded in fairness or equity fail when procedure is absent, why attorneys lose cases without reaching the merits, and why authority, not correctness, controls judicial outcomes. The reader no longer evaluates cases based on narratives or equity, but based on the existence or failure of procedural authority, which alone determines whether a case may live or must die. Thank you for the hearts. But if that is not into existence, guys, none of this stuff stands. So now that you understand, this alone kills all those sovereign theories that you gonna read. Procedures does. Thank you for the gift. Y'all understand what I'm saying? What do y'all think about the first chapter?
I think it's very simple to understand.
Hold on just a second, right quick, guys. All right. I'm back. Now, how y'all feel about that? How y'all feel about what y'all just read in the first chapter when it comes to procedure?
There's a lot of power in the understanding.
I'm trying to tell y'all, the Lawman series that I was telling y'all about, it is no joke, for real. When you read it, and you read it, it's gonna make everything clear to you. I promise. It's definitely gonna do that. Let me just show y'all what I mean. Let me just show y'all what I mean. because, like, again, I know people don't understand. So I'm going to show you. All right. So, for instance, let's look at this. That the people shall be secure in persons, houses, papers, and possessions for unreasonable search or seizures, and that no warrant shall issue to search any place or seize at any person or thing without probable cause, supported by oath or affirmation. Now, is that a self-executing clause? That's the question. Is what we just read a self-executing clause? So you feel like that this don't need to be defined any further through statute? Like, ask yourself questions. Like, let's read it again, and then I want you to ask questions that you need to ask to have if you want further understanding. So it says, unreasonable search and seizure and search warrants, so that the people shall be secure in their persons, houses, papers, and possessions from unreasonable search or seizures. Seizure or search, excuse me. And that no warrant shall issue to search any place or to seize any person or thing without probable cause supported by oath or affirmation. Right? So now, does that say enough to where it does not need to be defined in any statutory or court rules, etc.?
It says any place. I feel like maybe it's okay.
What about the definition of probable cause?
Yeah, so now you want to know what a probable cause is, right? That's not defined to you?
Yeah.
Right. Also, the people shall be secure in their persons. Okay, well, how are they going to be secure? Is that defined to you?
Nope.
So now, since that's not defined, then that means we got to what? It's not a self-executing clause, so now it has to be done in legislature, which means they got to write a statutory law about it. Correct? So when we go look at criminal code, search and seizures. All right. So now the authority of a peace officer to stop and question. So now you need to know. Okay, well, what gives them the authority to do that? A sheriff or other officer acting as a sheriff, his deputy, or any constable acting within their respective counties. So now you don't even know, let's go back and look at it again, because you didn't know this. You didn't know it was a sheriff. You didn't know that it was a deputy. It didn't say that, did it? It could, if it didn't say that, it could have said, hey, the attorney general or the clerk of the court, right? Because they are government actors, are they not?
Correct.
So therefore, this needs to be defined. So first it says who? A sheriff. Who has the authority to do this? Because when we go back, and look, it didn't say that. It didn't tell you who. Don't even mention it. What was it? I lost it. There you go. So it says that the people shall be secure. Yeah, from who though? Who are we secure from? And how? You see these questions, who, what, when, where, and how that you got to ask. And if you got to ask those questions and it's not stated and fully defined in the Constitution, then that means that it leads it over to who? The state legislature to define that through what? Statute. If they defined single thing in the Constitution, shit, you think you're going to want to read it? I'm serious. Y'all think y'all going to want to read all of that? You wouldn't have no choice, but that'd be a long-ass Constitution. Look, I'm going to show you. Alabama Constitution already long. So look how long all these amendments is. 772 amendments. Who reading that shit? Some of these things applies to certain different things, and they amending like amendment to amendment number 648. So they amended that one, right? All of these just keep going, keep going. So you need to make sure that whatever specific subject that you relating to or talking about, that you can come find those as well. But this 607, so imagine that being this along with the statutes, all being in one constitution. That's insane. It's already insane. We got 700 something damn amendments. That's crazy. But the reason why they keep having to amend these things because what? Things keep changing. Somebody said that's like reading a boring Stephen King novel. It would be. But again, this is the reason why they have to come over here and define these things, because now you need to know, well, who has it and why? Right? So in a public place, whom he reasonably suspects, that's the element, is committing a crime. They got to show proof of the probable cause, has committed, or is about to commit a felony or other public offense and may demand of him his name, address, and the explanation of his actions. So it says name and address. They can't tell you to show a fucking ID.
Wow.
Yep.
So now you got to understand the elements of the case this year. They say they stopped you and then you gave your name, etc. Then you didn't show no ID and they say, well, we're going to arrest you for obstruction of justice. Then you come right over here and you point this out and say, hey, they can stop me, but I don't got to get no damn ID. It just said my name, address, and the explanation of the action. That's it. That's it. It don't say nothing else, do it?
Nope.
So when they say, oh, well, we charge you with obstruction of justice, that's the reason why we took you to jail, et cetera. You didn't give us your ID, et cetera. And it's like, okay, so yeah, you're going to lose this. Violation of due process. This is a violation of due process. That's not what this says. You don't reach the full elements to literally charge someone for obstruction of justice when it says that if you're going to do obstruction of justice because they failed to identify when you stop them with a ID card. See, this is why reading is fundamental, because now this don't apply. If they try to charge you for obstruction of justice for that particular reason, this don't apply to you, do it?
Not at all.
And they don't even say last name on it either. It just says his name, address, and explanation of options.
That's it. And your name is your what? You can just say your first name. Listen, man, just say my name. My name is Eric.
I like that.
Yeah.
What if they're charging you with something else?
What do you mean?
We would look that up. Yeah.
Like if they're charging you for speeding ticket and then, you know, they broke this procedure.
That's a different story, though. This is why I have to explain stuff like this. Like, okay, if you are speeding, then I can show you in here that if they stop you in a car and you're on the public highway, listen to the words, and you are a licensee, then you have to show and keep driver's license on you and be able to show it to whoever stops you. But what's the key word that you have to be?
Licensee.
Exactly.
Yeah, licensee.
So if they try to charge you for failure to show proof of driver's license, they can't do that if you are not a licensee. If you turned your driver's license in and all that other type of stuff that people got you doing. That's why I say, like, those who try to go that route, if you don't understand due process, is like what I'm telling you and how to actually read these things in relations to that, then you gonna fail every time trying to argue the right to travel situation, because y'all not paying attention to what they're trying to charge you with. Are you a licensee? That's like I say, with a fictitious tag or plate. When they say that, it says that it's a license tag. So a license would literally mean that it came from the director. Right? So if they say, oh, you got a fake license tag. Okay, so how is in order for me to have a fake license tag, that means I took it from another car, placed it onto my car, or I altered it or altered, and I still have to alter a state tag. Do y'all understand what I'm saying?
Yes.
Yeah.
It's the words that's being said that matters. That's how you deal with it. You don't deal with it from running from it. All statutes are not laws. Okay, you gonna find your ass in jail quick saying shit, thinking like that. You need to point out because this is what they use to define. So remember, these are binding commands to control a outcome. So use it. If it don't apply, let it fly. You know what I'm saying? That don't apply to me.
Wow. This is big time.
But you just got to understand. That's why I'm trying to start y'all from to understand the basics. The basic principles of law applies in every area of law. So that means you need to understand authority, the source of authority. I don't care what charge it is. The reason why we can talk about search and seizure is because where does this source of authority come from?
Constitution.
The Constitution. And then that goes to the Alabama Constitution, right? So as you can see, here it is. Section 5, unreasonable search and seizure. So now, why does the state have the power to do this? Where does this source of authority come from?
Constitution.
Which Constitution?
U.S. Constitution.
Exactly, the federal Constitution. And the reason why is part of what? The 14th Amendment. Now the states is required the full due process of law. Search and seizure is a part of that. Equal protection of the law. Search and seizure is a part of that. Article 4, Section 4, which literally says that every state literally has the power to, the right to a republic form of government. Okay, that means you get to legislate law, but that don't mean you get to create laws that goes against the what? The federal government. You don't get to do that. When you start to understand it the way I'm telling y'all, you're going to win every time. Unless you just know you guilty as shit. That's a different thing. But even if you guilty, hey man, don't make them prove that shit.
There you go. You better make it hard for them.
You know what I'm saying? Just because the facts might be right don't mean the procedure's right. You still can win. OJ went home. Yeah, OJ went home. That's all I want to say. A lot of people don't like that, but shit, he did.
Yep.
Because of what? Evidence and procedure. So this is what I'm trying to have. This is where I'm trying to have y'all at. And everything I'm saying, like, this is what the Lawman conference is about. God's law, my salvation. That's what the whole conference is about. You're gonna literally learn how to understand what you're reading. You hear me? The Lawman Majority Status and Constitutional Enforcement Handbook. You're gonna know it to the T. You need to know it. You need to understand the basic principles. Hopping out here reading and jumping to everything without reading first. Trying something without understanding the procedures of the court. That's just like I asked the question, who is confident if they had to go into court and exercise their right? A lot of people said, yeah, I 10, et cetera, this and that. And I'm like, okay, well, what are you doing? The person was like, I'm doing a court warrant tow. And I was like, in what state you in? They said, Ohio. So I literally screen recorded it, looked it up for them and said, hey, you're doing it wrong. Because you cannot bring a court warrant tow into a criminal case. It is a civil matter. Just like it's a civil matter here. If I show it to you here in civil practice. So go to a civil practice. We go to remedies here. When we get to remedies, we go to court warrant tow. Then it's going to tell you the jurisdiction. Right? Courts always to be open. Right of action and venue. Here we go. The judge of a circuit court may direct the action to be commenced when he believes that any of the acts specified in subsection A can be proved. So now it's got to be what? You got to prove. It is necessary for the public good, or it may be commenced without the direction of the judge on information of any person giving security for the cost of the action to be approved by the clerk of court in which it's brought. So all of these things matter. So it's telling you that you have to commence this particular action here. That don't mean you get to put it in a criminal court. Because it's not. You got to bring it here. Read this shit right. You can't just I'm finna put an abatement in. But then it's only certain ways you can do an abatement in. And it's a civil form of matter as well, too. So you can't do certain things in a criminal court that you can do in a civil court. That's the reason why. Remember, civil is preponderance. Criminal was without a reasonable doubt. Got it?
Yep.
Got it.
Preponderance is just based upon saying that there's enough here to charge you with. You come, you go, you got to show proof of claim, et cetera, and all of that. Well, they saying they already got enough evidence to charge you with. And you are being charged. You innocent to proven guilty, but actually, you're really guilty until you come in and prove your innocence. Even though you innocent to proven guilty. Actually, it's a double-edged sword. It's a yin and a yang to it. Like, really, you are considered to be guilty until, and the reason why you're not is because they haven't gave a full verdict of you being guilty, but you are being charged. But this is why it doesn't matter what the public eye see or anything of that nature. Like, y'all can watch cases happen in front of you, and they're going to violate procedure. They're going to do things that is going to literally cause you harm. Seriously.
And if you don't call them out on it, they're going to get away with it.
They're going to get away with it. You waived it. You chose not to act on it. You didn't preserve it for the record. And if you don't preserve it for the record for the appeal, because like that's why when y'all try to do appeal or something and y'all do these little stuff, the appellate court going to say, hey, you didn't exercise your right. You had the opportunity to be heard. You didn't go.
Mm-hmm.
You chose not to go. And then if you didn't have the right to be heard, then you didn't put in here that you was properly notified. You didn't put that in there either. Improper service. So since you didn't exercise that, the appellate court don't have the power to hear that anyway. It only can hear the facts and the evidence that's already been placed on the record and the procedure of the court. You can't enter nothing else. You can't enter no new evidence, etc. You got to point out the defects. But again, that's the reason why I say it's so important to use your remedial writs before you even get to an appeal. Because sometimes you need to. They're going to be like, hey, why you didn't do a writ of mandamus? Why you didn't do a writ of prohibition here? You didn't exercise that. Y'all understand what I'm saying?
Yep.
I promise y'all it's more... Now it's more to it than you. I filed a declaration of political status and I declare my nationality on the record. And all right. Now I just get to walk in these courts and say, hey, you don't got jurisdiction over me. And they like, you gonna prove it? You know what I'm saying? Like, okay, prove it to us. Because right now, what it takes to bring a charge or a claim against you has already been established. All the elements are met. Now the duty is up on you to show, hey, what we don't have. But coming in here just saying some shit when the elements has already been proven to make a case ripe, that's different. Until you come and show something different. What's up, Freedom? Real thing. Y'all learned something today?
Man, yes, we did.
Yes, procedure is key.
That.
This is what it's going to take if we really want to win. We can't take no shortcuts. We have to go through it. We have to go through the law. We have to read the law. We have to determine what applies and what don't. You know what I mean? And that all depends on you. And believe it or not, some people will accept the conveniency of the court. They'll just be like, yeah, man, I don't feel like doing all that stuff, man. I'm just going to pay the ticket and go home. All right, holla. But that's their choice. They chose to do that. They chose to waive any of that right. Man, I just don't got the time to fight it. I need to get back to work. I need to do this. I need to do that. You know what I'm saying? That's what's going to be said. So that's the reason why I'm going to read this part to y'all one more time. Because, like, if this don't mean something to you, like, I don't understand. It says, this need, which means to provide legal services, was recognized by Mr. Lewis F. Powell, Jr., who was the president of the American Bar Association, who said, looking at contemporary America realistically, we must admit that despite all our efforts to date, and these have not been insignificant, far too many persons are not able to obtain equal justice under law. This usually results because their poverty or their ignorance has prevented them from obtaining legal counsel. Man. And then it says a wide gap separates the need for legal services and its satisfaction, as numerous studies reveal. Looked at from the side of the layman, one reason for the gap is poverty and the consequent inability to pay legal fees. Another set of reasons is ignorance of the need for the value of legal services and ignorance of where to find a dependable lawyer. There is a fear of the mysterious process and delays of the law, and there is a fear of overreaching and overcharging by lawyers, a fear stimulated by the occasional exposure of shysters. So all the poo shysty lawyers out here.
Occasional.
A lot of them.
Oh yeah, I got some people all the way right in here today. But yeah, so listen, it's just telling you. It's telling you right there. And to me, like when I read something like that, I don't know how y'all feel, but I be like, hold up, so you trying to say we stupid? And the reason why we can't get this is because we dumb? And because we can't, one, we don't even have the knowledge to know when we do need the service. So that means you saying we don't even know when we being harmed. Like they say, hey, let's just be realistically, man. The people are poor and they're ignorant. And poverty is because of ignorance. Damn. See, I take that shit personal. So that means every day I'm waking up, I'm reading. Ain't no way a lawyer finna sit up here and look at me and say some shit like that. I don't know how that make y'all feel, but that's how I feel. Now that takes us back to what? Joshua 1:8, right? Takes us back to Isaiah and Hosea as well. You're going to suffer for the lack of knowledge. Hey, I can't go there. I cannot go there, guys. I cannot be a lost cause in this particular situation because we failed to read ourselves. And they already said, even here, they say, hey, man, there's some poo shysties out there, man. Be careful. You know what I'm saying? They're going to take you blind. Take you for everything. I don't know what's going on. I'm finna have to reset all my internet. It's just been going off and on to y'all guys today. Greetings. So yeah, man, this is why like, and I want y'all to know too, man, for those of y'all that be commenting that crazy shit under my stuff, I don't answer to ignorance. I'm answering to you to continue on the algorithm. So don't think I'm giving you the privilege that I care to answer you. I do not, but it keeps the algorithm going. So that's why I answer you, right? For your engagement, not because you're right. Especially when you see me say thank you for your comment. That's literally what that's all about. Bro said, I want all the smoke. I know that's real. You feel like giving them the smoke today, bro? I've been waiting. I'm gonna have a day, man. I'll give somebody their chance to come up here and we're gonna sit here and listen. For a little second anyway, till they start getting too crazy. That's just like, man, listen, I'm telling y'all, we was live the other day, and it was this woman came in there. She was like, yeah, I don't do that. I don't go to court. I ain't going to court. I use the four corners of the paper and I send it in and I'm done. That's all I got to do. And then she was like, the first thing she said, but I did a habeas corpus and the judge ain't hear it. I'm like, so you in jail? You feel me, bro? I'm like, so you in jail? So why you in jail for? I think, hey, Mel, wouldn't you on that
Niggas
night with
don't
us?
even know when to fail certain things.
Yeah, I must have
I was
missed that one.
on TikTok.
Yeah, we
Word,
was on
me
TikTok.
too.
Man,
Where
listen.
was just that, Eric?
We was on TikTok. Y'all know I be on TikTok. For those of y'all don't know, I be on TikTok every night. We be on TikTok to about 12, 1 o'clock every night. We be up. I usually get on about 8, sometime 9, but we'll go about 4 hours, 3 hours, 5. We just be up. But anyway, it always somebody to come in there and say some crazy shit. Just like today, dude was saying something crazy, and I'm like, look, man, go commit the felony and show us. Get it on video so we can know. Like, we don't want to hear you saying anything because, like I said, most people talking don't got a car. They ain't got no transportation. They scared to leave their fucking house. Real talk. And y'all be sitting up here, y'all be liking the hell out of these people's stuff, and it's like, do you even know this person? Yeah, like what? Like, yeah, okay, they saying all this shit. They'll make it sound so good, and then you ask them, did you do this? Nah, well, we need you to go try it before you start passing out information like that. Real talk. I done been through the fire, though. That's why I can tell you what ain't gonna work, what will work, and what I've been using that always gonna work every single time. I'm not finna keep fighting with these people over some. Listen, I want to make it to where they can't say my shit some sovereign citizen talk. I don't want to hear that shit. Downgrade me and all that shit. Dog, hell no. We ain't doing that. So we're gonna do this the right way. And ever since and now y'all don't hear me say comes now the American state national, such and such. I don't say none of that shit. What's the point? Because when I start understanding that everybody got equal rights and due process, equal right of protection of the law and the right to due process, what the fuck are we talking about then? That means now it ain't no exclusive person in court. You ain't got no special privilege or right when you step up in here. Everybody, even if you a foreigner, illegal immigrant, they got the same rights as somebody that has citizenship here when it comes to right and due process and equal protection of the law. They got it. That means they got the right of search and seizure, all of that, warrant. They got all of that. The only thing they don't have is a political right, the right to vote and the right to sit in a seat of public service as a public official. They don't have that right. But when it comes to, and they don't have certain beneficial rights that only citizens of the United States can have, but they still get some. Because we'll let your ass come over from another country and we'll give your ass about $1 million that we can't get over here. We'll do some shit like that. Quick. It made me want to leave the country and come back. Goddamn. Hey, I'm going to leave the country, go get a citizenship somewhere else, and then pop back on y'all. Pa-da. Yeah, let me get that $1 million y'all got over here. So, and look, they ain't gonna stand in, and then guess what? They can't even deny me my citizenship to come back. I'm from here. That's a human right. I got the right to change my nationality and to go back. As soon as they get to me, bam, I'm back. Citizen, baby. Shit. You feel me? We up in this thing, boy. Don't play with me. Shit, let me get that. Hey, and guess what? It ain't nothing they can do about it because it's going to be written. Whatever they words say, that's their procedures. That's what they have to do. If you reach the elements, guess what they got to do? They got to give it to you. That's the thing about I like about the government. Hey, man, these your words. You said this. You got to do this. Word for word. That's why I love this shit, y'all. I love it. And I know we ran some people off. Y'all will be all right, though. Y'all, I promise you, those who were in here with us all the time, et cetera, don't like what we saying today, give them a year or so. Give them a little time. I promise you they're going to be back. Hey, man, you was right. You was right.
We're going to run into the truth. Yeah.
You was right by what you said, man. Yeah, I see. Y'all doing all this winning? Yep. So that's why I'm saying people be like, well, why you don't do the executive letters and stuff like that no more? Because you got to understand, What we were saying in the executive letters, it was a lot of, only way we was winning with those is because what we were saying according to law, not all the other stuff. It's actually what pertained into law. So I'm like, hey, how can I take what I'm saying into this executive letter and literally place it on actual documentation that's going to be accepted into a court through motions, affidavits, and things like that? Once I figured that out, it's over with. I don't even mention none of that shit. Because now it's just the substance and the form of law that we're using. The substance of equity and the form of law. That's all I'm using. I don't need to use it because equity is everywhere. Literally, equity runs parallel to law. Equity just don't pick up after law fails. No, equity begins with law. And it keeps going even when law fails. It will balance it. That's powerful.
And this is how we bring all of this corruption back to justice, back to equity.
It's the only way.
Because
you're absolutely right. That's the only way. So that's the reason why. Like, let me just show you how upset people get. I got to read this one. This person said this shit, brother. I was like, did you really say this? I got to read it. And if y'all don't like me sitting on here talking about y'all on here, then all I can say is stop commenting that dumbass shit. Because, yeah, I'm going to troll you when I get on here. Y'all been trolling me. I will return it. I promise. I got to show you what this dude said. Dude said, this shit will never end. I see it. Why are people looking outside of themselves for remedy? Everything is within. Why do you care what some law dictionary, case law, or codes? Isn't the government created from you? This shit is nuts. That's what he said, man. Woo-wee. See, that sounds like you so frustrated because you don't understand it. That's what I get from people. You mad because you don't understand something. Read more. Comprehension. Study the definitions. Right? I said what nuts is I actually use this to win and win many cases for my clients. What I'm supposed to do? Not win? Like, what y'all want us to do? Not win? Oh, they over there winning with the rules and statutes of the court. They still slaves. Shoot. Then one dude said, do not learn law from someone who is not a lawyer or a law professor. It's a scam. I said, put a name on it. Make that claim in court. That's what he said. Don't learn it. I said, put a name on it. Yeah, I put a fucking name on it. You badass. Say the shit. Say, Eric Ingram Bay, you are a scammer. Say it. Say it with your fucking chest out so I can take you and make you prove it in court because that's defamation. So let's do it.
Oh, man.
Yeah, y'all talk that big shit. Put a name on it. Man, I'm peaceful, man, but you know, I'm with the bullshit too. If y'all want to be on it, we can get on it. It ain't no problem.
That's wild.
Look, somebody said this.
Get him.
I got a question. Where does it say the Constitution anywhere that they have the authority to change the language or make up their own language? In other words, legalese, stop using their language, bro. You sound very ignorant. So let me explain this to you. Okay? The Constitution gave legislature, Congress, the power to legislate on particular subject matters that are not self-executing clauses. I want you to understand that. Okay? Yeah, they're not making up. They're doing what they're supposed to do. Right? So what else you want to use? You want everybody to be able to use their own definitions. Do you know how fucked up we would be if everybody got to define what the hell they mean by their own terminology and there's no base foundation in law for us to have an understanding? You will be totally confused as what y'all doing right now, causing confusion. You the same person, yeah, I don't follow the rules. Well, guess what? We know all people who follow the rules and rule breakers, we know where y'all end up at. Always have. From school, your ass ended up in ISS. That's isolation in damn jail. Shit. That what you want? Go get it. It still trips me out, though. That woman was saying she do not go to courts, but she was writing the habeas corpus. And I'm like, okay, so you in jail because you didn't go to court? Well, I tell you, man. Then somebody said, how about we all learn to tell them to suck our... Yeah, we ain't saying that word. Since they want to operate by secret rules that people cannot understand without law school, which would make sense if it were a job we were interviewing for it, but it hinders our freedom and personal autonomy. I said, laws are not hidden. They are made open to the public. That's what ignorance of the law... That's why ignorance of the law is inexcusable. Like, that's just... That has to be exposed. But I could go on, man. I could read some crazy damn stuff in here to you. The fact that somebody said it. It's the fact that 20 to 30 people will come and like that shit right behind them. I'll be like, wow. Yeah. Let me get up off here with y'all because I ain't finna do that. 20 to 30 people? That's just like y'all sit up here and let somebody literally comment that a citizen is stateless. Y'all let somebody tell y'all that, and then about 100 of y'all like that shit. Can anybody explain to me how a citizen can be stateless? I'm waiting. I want to fucking know right now. Anybody?
Yeah, that's crazy, man. Citizens.
It don't make sense. In order to be called a citizen means you belong to a state. You belong to a sovereign government in order to be a citizen. So how is a U.S. citizen considered stateless? Especially when the 14th Amendment says that they are a citizen of the state wherein they reside. Explain to me how that is stateless. I'm trying. The quiet man want to know.
That be them free men, right?
Yeah, that's them free men. Yeah, that's them free men and them free white persons. They the only one that got exclusive rights. Everybody else is stepped on. You ain't shit. Let them tell it. Well, since you're not white, since you're not a free white person, I'm sorry, you blacks just gonna have to go find you something. Y'all literally let that motherfucker talk to y'all like that too. Man, listen. Y'all be letting people talk to y'all crazy. Y'all be liking it and agreeing. That man just literally said, yeah, you blacks just gonna have to find
You blacks. What?
Basically, hell. I mean, I'm just doing what they do. I'm reading what I want to read and saying what the fuck I want to say about what they say. Even if they didn't say it that way, I said it that way because they statuses don't matter. We don't follow those rules. We make up our own terms of what you meant. I mean, shit, that's how y'all do the government. The government says person means a living being, right? Person, human being, and individual means a homo sapien, and it includes infants that is born from their mother with a beating heart attached to an umbilical cord. That's a corporation. Hey, dog. That's a corporation. That's not what that means. And I'm like, damn, bro. The statute said that this is what this means, but that ain't what Black's law says. Well, Black's law says that you need to stay up to date with modern law. Hey, man. I love y'all though. But this should be fun. I have to take humor from it because They be calling me all kind of stuff, man. All kind of names and shit. You know. But I thought the point is to win. Ain't that what we want?
Yeah.
The only thing, yeah.
That's the only
I
thing.
thought that's the
Yeah.
point. We want to win. Shit. I think to keep trying something and not getting a win and what you want is insane, is it not?
Repeating the same thing over and over again.
Yeah, I remember a lot of those arguments back in the day that people present. Those are like 98 through 2000 arguments from those militia groups. I was in a certain facility that, yeah, it was.
Bro, you said 98 we in 26 and that shit ain't still been proven yet.
And they still using those points, man. I'm like, man, that shit didn't get us nowhere then.
Somebody said, I guess I'm still lost on the part about none of them even being in office or having a bond of oath. They definitely in office. They definitely have. Some of them have bonds of oath. There's some that don't. There's some they might have had it when they first started. Then they bond might expire, etc., and they forget to go do it. You know what I'm saying? So for that particular reason, whatever. But yeah. But the oath, they have to have one. And if they don't, then it's your duty to do, it's the people's job who live in that particular area to do a quo warranto, because they absolutely holding the office. And this is my thing. If there is literally, and it's just by what people say. So for people who say that there's no judge that holds a oath or a bond, there's nobody sitting in these offices. They're all just acting like they are, but they're not. Okay, well, there's a remedy for that. It's called quo warranto. Go do it and let's see the proof. But you got to show proof that they not. So if you go down there to where they supposed to have an oath and it's an oath of bond on there and you still say, hey, this is it and this is not an oath of bond that is required. Well, okay, well, you just proved they do have one. So, yeah, we're going to fail the state of claim to grant relief. Case dismissed. With prejudice. Don't ever bring that shit back up in here again. Hey, that's what with prejudice mean. So, to give it to you, instead of saying it in a nice way, in a legal term, it means get that shit up out of here. Don't ever bring that dumb shit up in this court again. We ain't gonna hear it. We ain't gonna take our time to hear it. We don't want to hear that shit. Now, go ahead and pay another $400 and something just to file into this case so we can literally deny you after we take your money again. Yeah, keep on. You want to make it $1,200? You can try 2 more times. As soon as you do, yeah, you gonna pay that fee? Come on. Mm-hmm. Yep. It's a real thing. All I'm saying is this, guys. Any theory that exists, you take it, apply it to law. If it stands up with law, it's no longer a theory, it's truth. That's the point of theories. They are to be tested to see if they can go through the fire and still remain true. If you take it through the fire and it's not truth, you got to let it go. It sounds like it's about to storm over here, y'all. I'm enjoying talking to y'all, but I might have to get off here. Because now my baby... You say what, bro?
Sorry, go ahead. So the person that was asking about the bonding issue, they're saying, should they still use it or not use it?
What do you mean?
Quite. You said they were confused about asking about
whether the courts, whether the actual judges have an oath or bond. And all I'm saying is, if you have that question, go down, look and see if there's an oath and bond filed. Make sure that the oath, etc., says the exact same thing that is required by statutory law for them to have. And if it's so, then they right. But if you go down there and the oath and bond is not filed in the public place that it's supposed to be, etc., then now we got a right to question and do a quo warranto.
Okay. Got you.
Mm-hmm.
And you said it could be a couple of things that could be wrong, right? They could never have had one. It could be expired. It could be a couple errors
Yeah,
that
it
could
could be a
happen.
lot of things. Yes, a governor takes an oath to support both the U.S. Constitution and the state constitution and to faithfully discharge their duties. So yeah, they do.
Yeah, it just makes a lot of sense, like you've been saying, man, just to use the law that we know can work. Cause I've seen some craziness that people have filed, man, and never got anywhere.
Right. So here you go. Here's the answer to your question. I know you can't see on the screen, but I'll tell you. All right, I'm gonna read this from Alabama. You can find it in your state as well too. But it says Title 36, Public Officers and Employees, Chapter 13, Governor, Article 1, General Provisions, Section 3613.1, Oath of Office. The oath required by Article 16, Section 279 of the Constitution of this state may be administered to the governor by the presiding officer of either of the House of Legislature or by any officer authorized by law to administer an oath at any place of time. So they have to take one, right? Now, your job is to make sure they did. If they didn't, then they can't sit in that seat. It's just, it's really like on that level. It's just that simple. It's not even a guess. See, this is what I'm saying. We don't got to guess. We don't got to guess when the law already says these are the elements that has to be met in order for things to trigger and take place, right? So when I go look at the Alabama Constitution, we're going to go look up exactly what it says. It says Article 16, Section 279. Remember that for me, guys. What'd I say? Article what?
Article 16, 279.
Let's see.
I think that's what you said.
Let me just go to 279, Section 279. I told y'all we got 1,000 amendments here, so.
Yeah. A lot.
This is crazy. I'll tell you. Alabama, the only one I know like that, too. What'd I say? 270 what?
279.
Okay, here we go. Article 16, that's it. Section 279. All members of the legislature and all officers, executive and judicial. So that means executive is governor, right? Now, before they enter upon the execution of the duties of their respective offices, shall take the following oath or affirmation. So this is a actual constitutional. Is this a self-executing clause, Gauze? Yes, it is. Because I solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States and the Constitution of the state of Alabama as long as I continue a citizen thereof, and that I will faithfully and honestly discharge the duties of the office upon which I am to enter to the best of my ability, so help me God. The oath may be administered by the presiding officer of either house of the legislature or by any officer authorized by law to administer an oath. So it's there. It's there. Right? It's there. So since it's there, now we just go look back in the statute. This is what it says. That's written and defined even more here in the statutory law. They defined it anyway, even though they didn't have to. So, since that's there, now we get to move on. They got to have it. So, if they don't have it, then what we going to do, guys?
File a quo warranto.
There you go. We're going to jump on their head. So, and the quo warranto is a equitable remedy. And this is a civil in nature. So now we got to go look at the right of action, and the right of action and venue is assertion, et cetera, of office or franchise. So now, let me just pull this on over here for y'all. My bad. I could have put it over here and showed y'all. An action may be commenced in the name of the state against the party offending in the following cases: when any person asserts, intrudes into, or unlawfully holds or exercises any public office. So that's why I say, if people gonna say this shit, then go do a court warrant. Why y'all still sitting up here letting all these judges and the governors and officials that y'all say that don't have the power to sit somewhere, why y'all allowing them to do it? I'm just showing you there's a remedy for every bullshit that somebody says. And if this is so, take your bad ass and go do it. Oh, but remember, what I'm reading to you is a statute. So now remember, you don't follow statutes. Statutes is not law. So tell me how the fuck you gonna get your remedy? Boy, they hate it out here, don't they? They like, damn, he crushing us. Please stop. Can we get some air? Can we breathe? Hey, what can they say, bro?
Man, they can't say shit.
They don't even know how to answer it.
So listen. See, somebody said, I know several people who fact checked this, and they said they said, can they prove it? And when they prove it, take it to do a court warrant. What the fuck are they waiting on? That's the whole point. This is why I say we don't gotta guess. If they say it, show it, present it to the attorney general, show they don't have no oath of office. Here we are. We got to do it. There's a remedy for it. What we waiting on? But remember, people can't use this because they said statutories, they don't use those. They don't apply. Those don't apply. We don't do statutory. So, Ike, how they going to get their remedy then?
They're going to have to come up with another silver bullet.
Real talk. It ain't about checking. They should prove, and they should be able to act on it. Like, if you go look and you see like coming on here and telling us, like, hey, this judge don't got an oath. Okay. So why don't you tell your people that live in that particular district and community and county and tell them, and then y'all do a petition of a quo warranto. Otherwise, you're saying it's okay for them to operate in this way. So we can't blame the judge who doing it. We can't. It's the people's job. Are you going to let somebody sit and hold these particular places unlawfully? And if so, then hey. It's one of those things.
Kid, I got a question. If I can ask, or should I wait?
Ask.
Could that be used in a toll road situation? Because I've recently got an email back when I asked this particular toll road authority, hey, what's your policy on, your readers or calibrating your cameras? And they came back and told me, man, they literally said they don't have a policy regarding the calibration of their cameras.
There you go. You win.
And they only have a key performance indicator that requires their vendors to regularly tune the cameras. But it's not a policy. I mean, it says they have a KPI, but they literally told me they don't have a policy. So
there's no procedure, there's no steps, there's no proof to make sure there is a form of calibration to keep up, et cetera, with these particular cameras, et cetera. If not, then they can't use those things. You're finding the defectiveness in them. And now you're making them question. You're showing doubt. And once you place doubt into situations, they start to lose forms of jurisdiction in the relate. Well, they start losing proof of things because of you creating that doubt. But that's just called asking the right questions. Somebody said, I have a question. If a judge is attorney, is that a conflict of interest? Just depends on the situation. Just depends on the situation. All right, guys. I've been on here long enough. I gotta get some things together as well. I hope that everybody learned something. Don't forget that the car is still going to be given away. You still got plenty of chances for those of you that do want to enter. Make sure you do so. Do exactly what's said on the flyer. Guys, stop trying to come up with shit to find a way to do some shiesty shit. Y'all wouldn't believe half the stuff I get asked about this type of stuff. Like, just do what's on the flyer. Any flyer. Just do exactly what it say. And everything will be fine. But if you're trying to do, you know what I'm saying? It's two options here. It's Zelle and cash. We're not taking no other forms of payment, no other, and for this particular situation, no other type of way. You need to figure it out. You understand what I'm saying? That means if you got to find a buddy or whoever, or go get these particular accounts set up, then you got to do what you got to do. Y'all don't force Walmart to do no shit like that to make them change something. Why the fuck I got to change it?
Thanks.
You know what I'm saying? Like, people will literally try to pressure you like, oh, you supposed to. No, I'm supposed to do shit. You supposed to respect the establishment of the business or keep it the fuck moving. Like, what do you want me to do? I can't bend the knee to everybody's needs at every single time. I'm not Superman. And if I was, then I probably would fly some of y'all to the moon and never bring you back down. Like, for real. I would never bring you back down. You can stay up there. This is where your kind lives now. On the moon. Real talk. I wish I could, though. I wish I could help y'all in every single aspect to meet every single one of need that you want. But I can't. Can't do it. All right? Can't do it. There always has to be a base. And that's the reason why the law is written the way it's written. Because if we all wanted to use our own terminology and right of action and all of that, then is it really going to be just? And I don't think it would, because y'all going around here saying certain things don't apply. Like, if you let this community have it their way, then there would be no public regulations over the highway. So that means that y'all want people, and this is an honest thought. You go buy a brand new car, you come off the lot, right? You put insurance on it, everything. As soon as you step out here on this page, somebody hit your shit, and they practicing all this sovereign stuff. They don't got insurance, they don't got nothing, and they hit you in an old school 1964, and it looked like it was a demolition car, and they just smoked your brand new shit because you know it can't handle them old cars on that type of impact. So now all your shit just came apart, and then this person out here saying, hey man, I don't got insurance, and they don't got no money, they don't got no property. They don't got nothing.
Might be a fight.
How you gonna get your remedy? How you gonna receive anything out of this? Now let's say even you didn't purchase insurance because you want to stand on that shit. Now you just stuck with a car with nothing. There ain't no insurance to help you out. There ain't nothing. They ain't got none. You ain't got none. You just bought a brand new car and you assed out right now. So you think that is right for that to happen to people? Like, so who, you know what I'm saying? You got to ask yourself, is that particular stuff right?
Oh no. Shoot, no.
Now, I don't think that them regulating the public highway and commerce, et cetera, and stuff like that should prohibit you, you know what I'm saying, should be able to prohibit you from exercising certain rights, nor should it take away your right of due process and equal protection of the law. That should never happen. I think that should always stay there. But I don't think that the fact that, we got to be honest, man, there's 18-wheelers on here, people falling asleep at them, crashing, running through 10 cars, right? You know what I'm saying? But y'all don't think these people should be held accountable. There shouldn't be, oh, well, he got the right travel. Yeah, it don't matter if he ran over 10 people. So what? Well, where's the crime? Where's the You know what I'm saying? Like, that's what they believe, bro. Seriously. I just want to be straight up about it. You have to look at it, and everybody's looking at this from the lower level. Come up. I want you to sit on top like you operating a kingdom. You governing this kingdom. Do you know what's going to happen if you remove that?
Chaos.
Where is the victim? Y'all got to understand the victim is the people as a whole. if you go out here, and I want you to understand, if you go out here and you let out 1,000 rounds in public, well, and let's say you don't hit nobody, but you let them go. You put everybody in a frenzy, everybody trying to run and get somewhere, cars having an accident, all kind of shit, but you never hit anybody, and but you definitely gonna be held accountable for that. It's because you can't do shit like that. It's the public. You can't allow, otherwise you're gonna have a riot so big that you can't control. Now, I understand what you're saying. I know what you said. I just wanted to give a different thought or perspective of it. But yeah, I just really want y'all to understand, like, rules and stuff are there for a reason. And it's there to protect the fairness, et cetera, of the people. But you also got to understand that they write a lot of stuff and they try to sneak this bullshit language in there. You have to read it and see it for yourself, because they did put it in there. But it don't mean that it stands as anything. It's void. But if you don't understand the law yourself, then it's going to always apply to you. Because you're going to never, like I said, like what the lawyer was just saying from the American Bar Association. He said, hey, the people are poor, they're ignorant, and they don't even know when they need legal services. That just means you don't know when you're being harmed. So if these things takes place, this is why our society is today. This is, I think Freedom told me the other day, I want to make sure I say this right. It was 5 million cases, and out of 3.5 million of those cases, they all were default, which means nobody showed the fuck up. That's crazy.
What kind of cases were they?
They were all civil claims.
Oh.
What?
They can't carry a criminal case without you being present. So that'll never happen. You will never default on a criminal case because they can't carry out a trial without you being there. So that's why they have to protect the right and the opportunity to be heard. That's why they're going to bring forth the body. They put out a warrant to bring you there to make sure that the process continues for the court case. You know what I'm saying? Like, it's a real thing. But see, now you got 3.5 million people, and I wonder how many of those people were just sovereign citizens too. But anyway, but 3.5 million people that just didn't show up. And I guarantee you what they put in those court cases was not enough weight at all to make a standing against you. But if you never challenge it, you don't know. You don't go to the finish line, you don't know at all. Well, make sure you guys are there. God's Law, My Salvation is Saturday, guys. We are going to be in the Atlanta area. I will be there around, I think, Thursday. Either Wednesday or Thursday. But we'll be there for a while. So we're going to be, kicking it, getting it on. Going to visit a couple people my family that's around, stuff like that. And going to have a good time. And then we're going to handle business. And then we're going to have some more good time. And I'm bringing my ass back home. But we're going to do it. And like I say, if you want to know this way, then meet me at this conference. If you don't want to learn it this way, then, just best not even come on here and try to argue with us, because this is what we're going to stick to. You can't change our mind. We already seen it from your perception. We didn't shit happen, right? We seen it. That's been around too long. There's no way that this particular shit gets to go on and travel on for damn near 70, 60 some years. And then here we are today, and none of this has never fallen and been proven into any forum or court. So why keep going that route? You know what I mean? Uh-oh, we got somebody else. Let's see what he said.
Man, one of them guys that wrote one of those books back in 2099 put a lot of good information in there, but he ended up, I looked up on YouTube, see dude bleeding out, man. I'm like, wait a minute, if your information was so valid, the hell you doing bleeding out? I was tripping off that.
Look what this dumbass dude just said. Statutes are not laws. U.S. Constitution is our laws. Agree to that. Case law is Cole's law. Hey, he said, so I said, definitely not true. The only way a statute is void if it's caused a conflict in chain of command and the superior law supersedes. True. He said, you're obviously a lawyer who benefits from a case law ping pong. I'm not a lawyer, first and foremost. Codes and statute have been ruled unconstitutional, null, and void. Some of them have by Supreme Court over and over. Some of them have. It violates separation of powers. Sad you resort to treason for a paycheck. You're going to jail soon. People are demanding justice. You're a crook. Matthew Antonio Analetto. You want to make that claim in court, buddy? That's all I want to know. You want to make that claim in court? Be bad enough to take this shit to court and put it on record. You drank Bud Light anyway. Get the fuck out of my face.
That's a lot of them dudes got their head knocked out back then, man.
Boy, you drank water, Bud Light. Put some hair on your chest. Get some whiskey.
Tap water.
And you feel me? Don't nobody want to drink that water. Everybody that drink Bud Light, no, you got to go to the bathroom. We don't want that. Yeah, you might well take your case. You might well take your case of Bud Light and sit on the toilet, sit by the toilet, bro.
Remember that book, Cracking the Code?
Yeah.
That's what I'm talking about. The guy that wrote that, man, that dude ended up pleading out, going to the pen himself.
Damn.
And we was religiously following that shit, man.
And can't even exercise the win with everything that he wrote about being passed around, Crack the Code. Everybody probably got, that's a book that's passed around too.
Yeah, that shit, I'm telling you, man.
The Redemption Manual 4.5. That shit been what? Hey, so you mean to tell me the first Redemption Manual wasn't enough?
I guess so, because it didn't. I don't know nobody that won off of it.
Man, I just want to know, is Antonio like, yeah, Matthew Antonio, whatever your name is.
I had that shit.
Bring that shit to court, man. Put that shit on record. Y'all just keep speaking like it ain't no consequences. I'm gonna show y'all some real consequences. The last person that tried to do this bullshit, y'all remember his name? I can't remember, but he was like trying to troll and shit. Boy, I made that man delete his whole entire pages, delete everything he said. Just don't know I screenshotted everything, so I got you. As soon as I told him, oh, this defamation. Delete. Oh, this identity fraud. You trying to use my name to establish stuff with the IRS, et cetera? Identity fraud. Oh, yeah, I was just, I know, shit get real. I gotta take this route because I like to slap. So it's best for me to take this route. I like my daughter. I like to be with my daughter. I like to be with my children and shit like that. There's a lot of disrespect that deserves a slap. I come from that era. So in order to keep from me having to pay you because you wrong, let me just go and sue your ass. Straight up.
Man, you know, there was a lot of people who were flooding the courts during that time too with paperwork, and like you said, you don't think it's a reap. Man, some of them were getting hit with like paper terrorism charges and shit, man.
They still hitting you with that.
This was in the joint. You already doing time, now you're getting hit with a paper terrorist charge.
But you know why they saying paper terrorism? Because in those they are acting what? Belligerent.
Yeah, they were saying some crazy
They'll
stuff.
come in there and say a belligerent combatant. You a belligerent combatant, so you making threats?
Yeah, they were saying some.
Gotta move civilly, man. Listen, y'all, I love to have fun. I promise y'all, I do. So, I like to talk shit. I can come on here and I can be calm and I'll let a lot of shit slide, won't say nothing, and just whatever, let y'all have y'all fun. But just know, one day, when I pop my shit, you getting it all day long. I'm gonna let you have it. Cause y'all really be sitting out here talking, and it's like a lot of stuff y'all say, man, this is why I say, for real, for every person who be talking that gangster stuff, man, put some football pads on. Let's line up 10 yards apart. You get the ball, and let's see if you can score this touchdown. Ain't no juking nothing. It's a straight line, Oklahoma drill. See, this is what made people go play basketball.
Bull in the ring.
Yeah, that type of thing. See, this is what set people in the stands and realize sports ain't what they want to do. You know what I'm saying? These people be talking so crazy, man. Man, I'm gonna put you in a real situation and help you understand. You know,
The coaches used to do. They lay down, and whoever he dropped the ball on, you got to get up, run on the other dude. Another dude got to smash that cat.
man, listen, that's the reason why a lot of people went to hustling and all this other stuff in the streets because they couldn't compete in something real. That's the reason why they picked up a gun because they got hit in their mouth on some real shit. I keep saying that to a lot of people. A lot of y'all just ain't never been hit in y'all mouth before. You ran. And it shows you ran. Because y'all come on here with straight disrespect. Real men that know shit happen can pop off always come with respect. And they ain't tolerating no disrespect. So even if we got a disagreement, it's respect. But to come over here and say shit that you're not going to run your mouth about in somebody's face, because as soon as you see somebody in their face, you get to shaking and shivering and turning all red and shit and looking like, damn, what the fuck? I done seen too many people get walked up on like that. Yeah, what about all this shit? Yeah, I was just saying, man. Yeah, I know. I mean, I'm here now. I'm in your face. Then it turns different, right? All the time.
Yeah.
I mean, I ain't no bad dude. I don't fight. I hate confrontation. I'm gonna walk away from it before anything. But boy, you want to agree to a Mortal Kombat? What state gives us the right to Mortal Kombat? It's one state that says, shit, you got the right to Mortal Kombat, to death. You just got to sign the waiver. Which one is it? Is it Minnesota?
I don't know.
I promise y'all, it's a state.
Oh, man, I ain't know that one.
I'm going to find it. Only 2 jurisdictions. Okay. Let's see. Jurisdictions basically allow consensual fighting under specific conditions. You got Texas.
Oh shit.
Okay.
Well, they call it mutual combat, but I said mortal. But shit, you know, mutual combat.
My man said fights.
You feel me? Finish him. Test your might. This is why I won't get a Switch. Way too emotional. Bro said he way too emotional. He don't need no Switch. Hey, listen, this is why. Listen, I'm telling you, if I feel like if I gotta go to a place and I gotta carry a gun, bro, I ain't going. I done been into too many near death situations. I done seen bullets fly beside me, car wrecks, all kind of shit. Man, listen, don't nobody own my life but God. When God say it's time, it's time. I'm not finna walk around in fear with a damn gun around me everywhere I go. But hey, don't think this shit ain't around just because it ain't on me, though. Do not think that. Shit. Do not think that you could just pull up on me at a conference or something and think that we not prepared for some stupidity. You know what I'm saying? We hey, stay dangerous is what I've always been taught. We don't move like that. We ain't moving ignorant and stupid, but we ain't finna cause no problem. We're gonna make sure everything's safe for everybody around. But at the same time, man, come on. These just words. If these words drive you to emotion, then yeah, this ain't a place for you to be amongst men and women. Because there are some women way stronger than men, especially when it comes to emotions. Real talk. But anyway, man, I got none but love. I had fun with y'all today. Great talk today. I love to have fun. This was fun to do today as well as read. But again, like I say, it'd be so many people that just be talking crazy. And it's like, y'all can have it, man. Y'all can have it. I promise you. Because we're going to still win. So what y'all going to say when the next win we post and we use statues? Y'all going to say those don't apply. And then somebody just got paid $150,000 off a lawsuit. What y'all gonna say? The statute don't apply. The cause of action don't apply. It's a statute. But they won with it. You know?
And let them lose enough cases. They'll figure it out. I ain't trying to do all that crazy shit.
You feel me?
Been there.
You get yourself together real quick. When you start getting them L's up under you, then it start costing you fees, and then it costing you $500 to get your car out every single time. In a state park in Seattle, Washington is where you can challenge someone to Mortal Kombat. See, I told you. Somebody said, what? Shit.
Damn.
Hell yeah. Like it's one state. What state is one state? If not, it might be Oregon. But I think it's one state that don't even. They like if you want to do drugs, do drugs. If you die, you die. That's you. We ain't,
Probably Oregon.
we ain't charging you for that. Like, hey, it's some crazy stuff, but it's real though. I understand it. You self-government. Go ahead. Go right ahead. So, how many of y'all are attending God's Law My Salvation? We ready for you. Comes with 4 ebooks.
Get the live stream.
Yeah, okay, that's cool. It comes with 4
Yeah,
ebooks.
I might do the live myself too.
4
I was
great
trying to go
ebooks.
out there for you, man. I'm trying to meet you, bro. But the court dates is lining up just in the same time frame, so it's like I still gotta be around.
Man,
It's
you
gonna
doing
take
your
a
job.
bit of a drive. Yeah, we getting it. Yeah, thank you, man. Yo, and I did the whole 9 yards. You told me about the therapist, and I still found me a spiritual counselor that has a license here in New York.
Yeah.
So now I'm using both. I'm about to use both on. I already filed everything. I already set everything in. But yeah, I definitely threw that in there too. Thank you. I appreciate you for that.
Yeah, that's powerful. That's gonna make it even better for you. Get them punitive damages up. Straight up. All right, guys, that is literally the end for us today. Again, appreciate you guys and y'all time, man. Be ready. This week is gonna be a lot going on this week. Yeah, Wednesday I will be having class with y'all. Sorry about last time. I went home, all that stuff. Didn't even, got with the fam. Y'all know how that goes. Sometimes you just forget about everything when you with the family. So, but we will have one Wednesday as well, and we're gonna keep it pushing. So, y'all have a great day. We out of here.